Be ready. Start. It is seen that verification of the character and antecedents is one of the important criteria to test whether the selected candidate is suitable to a post under the state. Though he was found physically fit, passed the written test and interview, and was provisionally selected on account of his antecedent record, the appointing authority found it not desirable to appoint a person of such record as a constable to the disciplined force. The view taken by the appointing authority in the background of the case cannot be said to be unwarranted. The tribunal, therefore, was wholly unjustified in giving the direction for reconsideration of his case. Though he was discharged or acquitted of the criminal offences, the same has nothing to do with the question. What would be relevant is the conduct or character of the candidate to be appointed to a service and not the actual result thereof. If the actual result happened to be in a particular way, the law will take care of the consequences. The consideration relevant to the case is of the antecedents of the candidate. Appointing authority, therefore, has rightly focused this aspect and found it not desirable to appoint him to the service. Consequently, it has to be held that the respondents were guilty of misrepresentation and fraud perpetrated on the appellant employer while getting employed in railway service and had snatched such employment which would not have been made available to them if they were not armed with such bogus and forged laborer service cards. It was clearly a case of fraud on the appellant employer. If one such fraud is detected, the appointment orders themselves, which were found to be tainted and vitiated by fraud and acts of cheating on the part of the employees, were liable to be recalled and were at least voidable at the option of the employer concerned. This is precisely what has happened in the present case. Once the fraud of the respondents in getting such employment was detected, the respondents were proceeded against in departmental inquiries and were called upon to have their say and thereafter have been removed from service. Such orders of removal would amount to recalling of fraudulently obtained erroneous appointment orders which were avoided by the employer appellant after following the due procedure of law and complying with the principles of natural justice. The aggrieved are all those who had similar or even better qualifications than the appointee or appointees but who had not applied for the post because they did not possess the qualifications mentioned in the advertisement. It amounts to a fraud on public to appoint persons with inferior qualifications in such circumstances unless it is clearly stated that the qualifications are relaxable. No court should be a party to the perpetuation of the fraudulent practice. It is, of course, true, as noted by the tribunal, that the facts of the case in the aforesaid decision were different from the facts of the present case. And it is also true that in that case, pending the service which was continued pursuant to the order of the tribunal, the candidate concerned acquired the requisite qualification and hence his appointment was not disturbed by this court. But that is neither here nor there, as laid down in the aforesaid decision, if by committing fraud any employment is obtained, such a fraudulent practice cannot be permitted to be countenanced by a court of law. Consequently, it must be held that the tribunal had committed a patent error of law in directing reinstatement of the respondent workman with all consequential benefits. Learned counsel for the appellant submitted that once the labor court has found that the respondent was guilty of suppression of relevant facts and had also snatched an order of appointment which would not have been given to him had he not deliberately concealed the fact about the aforesaid prosecution against him for an offence under section 307 of the Indian Penal Code, there was no question of awarding him any lesser punishment save and except confirming the order of termination. The object of requiring information in columns 12 and 13 of the attestation form and certification thereafter by the candidate was to ascertain and verify the character and antecedents to judge his suitability to continue in service. A candidate having suppressed material information and stroke or giving false information cannot claim a right to continue in service. The employer, having regard to the nature of the employment and all other aspects, had discretion to terminate his services, which is made expressly clear in para 9 of the offer of appointment. The purpose of seeking information as per columns 12 and 13 was not to find out either the nature or gravity of the offense or the result of a criminal case ultimately. Thank you.